Nearly 70% of American workers do not know their basic legal rights on the job. That means the majority of people showing up to work every single day are completely unaware of the protections the law already gives them, protections that employers are legally required to follow. And the ones who figure this out? They get better pay, safer conditions, and real accountability from the companies that employ them. In the next 10 minutes, you are going to discover the foundational rights that govern every American workplace, the laws that protect you from discrimination and retaliation, what your employer is legally required to tell you, and the one area of employment law that catches even educated workers completely off guard. We will also walk through what happens when those rights get violated and what you can actually do about it. Stay until the end, because the section on retaliation might genuinely change how you handle your next workplace conflict. Employment law in the United States did not arrive fully formed. It was built piece by piece over more than a century of labor struggle, court decisions, and legislative action. Before the 1930s, the relationship between employer and employee was almost entirely governed by private contract, and since employers held all the bargaining power, that usually meant whatever the employer said went. Workers had no federal minimum wage, no guaranteed right to organize, and no protections against arbitrary termination. The New Deal era of the 1930s changed everything. The National Labor Relations Act of 1935, also called the Wagner Act, gave workers the legal right to organize into unions and collectively bargain with their employers. The Fair Labor Standards Act of 1938 established the first federal minimum wage, a whopping 25 cents per hour at the time, and set overtime rules requiring time-and-a-half pay for hours worked beyond 40 in a week. Those two pieces of legislation formed the oldest pillars of modern employment law. Everything that came after built on top of them. Then came the Civil Rights Movement and the explosion of anti-discrimination law. Title VII of the Civil Rights Act of 1964 prohibited employers from discriminating against workers based on race, color, religion, sex, or national origin. The Age Discrimination in Employment Act of 1967 extended those protections to workers over 40. The Americans with Disabilities Act of 1990 added disability to the protected categories and required employers to provide reasonable accommodations. And the Pregnancy Discrimination Act of 1978 clarified that discrimination based on pregnancy is, in fact, sex discrimination. Together, these laws created a legal framework that covers the vast majority of American workers in most employment situations. But here is what nobody talks about: knowing the law exists is not the same as knowing how it actually works in practice. And the gap between legal theory and workplace reality is enormous. Let us start with wages and hours, because this is where the most widespread violations occur. Under the Fair Labor Standards Act, non-exempt employees must be paid at least the federal minimum wage of $7.25 per hour, though many states have significantly higher minimums, and in those states the higher rate applies. Overtime kicks in at 40 hours per week, and that overtime pay must equal at least 1.5 times the employee's regular rate. The Department of Labor estimates that wage theft, meaning employers illegally withholding earned wages, costs American workers more than $15 billion every year. That number is staggering. And most of those workers never file a complaint because they do not realize what happened to them was illegal. One of the most common tricks involves misclassification. Some employers classify workers as independent contractors or exempt salaried employees to avoid paying overtime. Just because your employer calls you a contractor does not legally make you one. Courts look at the actual nature of the working relationship, who controls your schedule, who provides your tools, whether this work is central to the company's business. If those factors point toward employment, you may be entitled to overtime and other protections regardless of what your offer letter says. Now let us talk about workplace safety. The Occupational Safety and Health Act of 1970 created OSHA and established the fundamental principle that workers have the right to a safe workplace. Employers are required to maintain conditions free from recognized hazards that could cause serious harm or death. They must provide appropriate safety training, maintain certain records of workplace injuries, and they cannot retaliate against workers who report safety violations. In 2022 alone, OSHA conducted over 32,000 inspections and issued more than 4,500 citations for serious violations. Those numbers tell you just how common unsafe conditions still are across American industries. Here is a number that should stop you cold. The Equal Employment Opportunity Commission received approximately 73,000 workplace discrimination charges in fiscal year 2022. That is nearly 200 complaints every single day. And those are only the cases that actually got reported. Experts consistently estimate that workplace discrimination is vastly underreported, meaning the real scope of the problem is much larger than official statistics suggest. Under Title VII and related statutes, discrimination can take two main forms. Disparate treatment is when an employer treats an employee differently because of a protected characteristic, firing a woman for behavior that would be tolerated in a male employee, for example. Disparate impact is more subtle. It occurs when a workplace policy that appears neutral on its face actually has a disproportionate negative effect on a protected group. Both forms are illegal, but disparate impact cases are significantly harder to prove without careful documentation and legal expertise. Sexual harassment is also covered under Title VII as a form of sex discrimination. There are two types courts recognize. Quid pro quo harassment, which is Latin for this for that, occurs when a supervisor conditions employment benefits on sexual favors. Hostile work environment harassment occurs when the conduct is so severe or pervasive that it creates an abusive working environment. A single comment rarely rises to that legal standard, but courts look at the totality of circumstances, frequency, severity, and whether the conduct is physically threatening or humiliating. But here is what nobody talks about when it comes to discrimination law: the retaliation protection may actually be more powerful in practice than the underlying discrimination claim itself. Federal law prohibits employers from taking adverse action against employees who report discrimination, file EOC charges, or participate in investigations. An adverse action can be termination, demotion, schedule changes, or even subtle moves like suddenly giving you negative performance reviews after years of positive ones. Retaliation claims now make up the largest single category of EOC charges. And courts have consistently found that retaliation cases are often easier to prove than the original discrimination claims because the employer's reaction creates a visible paper trail. This brings us to a critically important concept, the at-will employment doctrine. In 49 of 50 states, the default rule is that either the employer or the employee can end the employment relationship at any time, for any reason or no reason at all, without notice or liability. That sounds devastating for workers. And honestly, it is a significant power imbalance. But the exceptions to at-will employment are just as important as the rule itself. Employers cannot fire you for a discriminatory reason. They cannot fire you in retaliation for protected activity. They cannot fire you for serving on jury duty or taking protected leave under the Family and Medical Leave Act. And if you have an employment contract, even an implied one, those terms can override at-will status entirely. The presence of an employee handbook that says termination only happens for cause has, in multiple court cases, been found to create an implied contract. The Family and Medical Leave Act deserves its own moment. Under FMLA, eligible employees at covered employers can take up to 12 weeks of unpaid, job-protected leave per year for the birth or adoption of a child, a serious health condition of their own, or to care for an immediate family member with a serious health condition. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.